Section 195, Disclosure of Interest by Directors. 1. A director of a company who has an interest that is likely to create a conflict of interest between that director and the company shall a. Cause to be entered that interest in the interest register established under Section 196. And b. Disclose that interest to the board of the company at a meeting or by written notice given to the directors immediately after becoming aware of the fact of that interest. 2. The director shall disclose the nature and extent of the interest. 3. A director who fails to comply with a provision of this section commits an offense and is liable on summary conviction to a fine of not less than 250 penalty units and not more than 500 penalty units. Skip Section 196. Section 197, Directors to act professionally. Except as otherwise provided in the constitution of a company, a director may, despite Section 192, act personally or by the firm of that director in a professional capacity for the company, except as auditor, and the director or the firm of the director is entitled to proper remuneration for professional services as if the director were not a director, provided that disclosure is made under subsection 6 of Section 194. Section 198, Use of company information. 1. A director of a company who has information in the capacity of that director as a director or employee of the company, being information that would not otherwise be available to that director, shall not disclose that information to any person, or make use of or act on the information, except a. For the purposes of the company. B. As required by law. C. In accordance with subsection 2. Or D. In any other circumstances. 1. Authorized by the constitution of that company. Or 2. Approved by the company by a written resolution circulated to all the members and signed by 3/4 of all members entitled to attend and vote on the resolution at a general meeting. Or 3. Approved by the company by an ordinary resolution of the company passed at a general meeting at which neither the director concerned, nor the holder of any share in which the director is beneficially interested, directly or indirectly, has voted as member on the resolution or where the holder has voted and the vote is not counted. 2. The approval under subparagraph 3 of paragraph D may be given before or after the occurrence of the transaction to which the approval relates. 3. The board may authorize a director to disclose, make use of, or act on information where the board is satisfied that to do so is not likely to affect the company. 4. A director of a company may, if authorized by the board under subsection 3, disclose information to a. A person whose interest the director represents. Or b. A person in accordance with whose directions or instructions the director may be required or is accustomed to act in relation to the powers and duties of the director, subject to the director entering the particulars of the authorization and the name of the person to whom the information is disclosed in the interest register. 5. Any monetary gain made by a director from the use of information which a director has in the capacity of that director as a director shall be accounted for to the company. Section 199, Civil Liabilities for Breach of Duty. Where a director commits a breach of duty under sections 190 to 192. A. The director and any other person who knowingly participated in the breach are liable to compensate the company for the loss the company suffers as a result of the breach. B. The director shall account to the company for a profit made by the director as a result of the breach, and C. A contract or any other transaction entered into between the director and the company in breach of that duty may be rescinded by the company. Section 200, Legal Proceedings to enforce liabilities. 1. Proceedings may be instituted by the company or by a member of the company to a. Enforce the liabilities referred to in Section 199, b. Restrain a threatened breach of a duty under Sections 190 to 192. Or c. Recover from a director of the company a property of the company. 2. Proceedings may be instituted by the company on the authority of the board of directors or of a receiver and manager or liquidator of the company, or of an ordinary resolution of the company which has been agreed to by the members of the company entitled to attend and vote at a general meeting or has been passed at a general meeting. 3. Subject to subsection 5 of section 19 and at a general meeting for the purposes of subsection 2, neither the proposed defendants nor the holders of shares in which all or any of them are beneficially interested shall vote on the resolution, and if all or any of them do vote, the votes shall not be counted. 4. After an investigation of the affairs of the company, proceedings may pursuant to section 234 be instituted in the name of the company by the registrar. 5. Where proceedings are instituted by a member, that member may either bring a derivative action under Section 201 or a representative action under Section 205 on behalf of that member and all other members, except members who are defendants to the action, and shall join the company as a defendant, and to that representative action the provisions of Section 349 shall apply. 6. The court, on the application of a defendant, may stay proceedings by the member if satisfied that, in all the circumstances, including the participation of that member in the transaction complained of, and the circumstances in which that member became a member, it is inequitable that the member should be allowed to have the conduct of the action. B. May order the member to give security for payment of the cost of the defendants. And C. May direct that the action or any part of the action shall be heard in chambers. 7. A period of limitation shall not apply to proceedings under this section, but in those proceedings the court may relieve a director from liability in whole or in part and on the terms that, in all the circumstances including lapse of time, the court considers it equitable so to do. 8. In proceedings under this section the court may, in the interest of justice, order that a sum of money found to be payable by a defendant shall be restored, in whole or in part, to members or former members of the company instead of to the company. 9. Where the court makes an order, the court may order that the necessary inquiries shall be made to ascertain the identity of the members and former members concerned and may give the consequential directions that may be necessary or expedient. 10. Proceedings under this section shall not be discontinued, settled or compromised without the approval of the court after notice of the proposed discontinuance, settlement or compromise has been given to all members of the company and to the registrar in the manner that the court directs. 11. Within the time prescribed by the notice, a member of the company and the registrar may appear and call the attention of the court to the matters which seem relevant and may give evidence and call witnesses. 12. Where the court does not approve the discontinuance or compromise, the court may give the conduct of the action to a member willing to continue the proceedings, or to the registrar in the name of the company, making the consequential orders regarding the parties to the action or otherwise that may be necessary or expedient. Section 201, Derivative Action. 1. Subject to subsection 3, the court may, on the application of a member or director of a company, grant leave to that member or director to a. Bring proceedings in the name and on behalf of the company or a subsidiary of the company. Or b. Intervene in proceedings to which the company or any related company is a party for the purpose of continuing, defending, or discontinuing the proceedings on behalf of the company or a subsidiary of the company, as the case may be. 2. Without limiting subsection 1. In determining whether to grant leave under that subsection, the court shall have regard to a. The likelihood of the proceedings that may follow. B. The cost of the proceedings in relation to the relief likely to be obtained. C. Any action already taken by the company or a subsidiary of the company to obtain relief, and D. The interest of the company or a subsidiary of the company in the proceedings being commenced, continued, defended, or discontinued, as the case may be. 3. Leave to bring proceedings or intervene in proceedings may be granted only where the court is satisfied that either a. The company or related company does not intend to bring, diligently continue or defend, or discontinue, the proceedings, as the case may be, or B. It is in the interest of the company or a subsidiary of the company that the conduct of the proceedings should not be left to the directors or to the determination of the members as a whole. 4. Notice of the application shall be served on the company or a subsidiary of the company. 5. The company or related company A. May appear and be heard. And B. Shall inform the court whether or not it intends to bring, continue, defend, or discontinue the proceedings, as the case may be. 6. Except as provided for in this section, a member or director of a company is not entitled to bring or intervene in any proceedings in the name of, or on behalf of, a company or a subsidiary of the company. Section 202, Cost of derivative action to be met by company. The court shall, on the application of the member or director to whom leave was granted under Section 201 to bring or intervene in the proceedings, order that the whole or part of the reasonable cost of bringing or intervening in the proceedings, including any cost relating to any settlement, compromise, or discontinuance approved under Section 201, shall be met by the company unless the court considers that it would be unjust or inequitable for the company to bear those costs. Section 203, Powers of court where leave is granted. The court may A. At any time, make any order it considers fit in relation to proceedings brought by a member or a director or in which a member or director intervenes, as the case may be, with leave of the court under subsection 3 of Section 201. And B. Without limiting the generality of this section. 1. Make an order authorizing the member or any other person to control the conduct of the proceedings. 2. Give directions for the conduct of the proceedings. 3. Make an order requiring the company or the directors to provide information or assistance in relation to the proceedings. Or 4. Make an order directing that any amount ordered to be paid by a defendant in the proceedings shall be paid, in whole or part, to former and present members of the company or a subsidiary of the company instead of the company or the related company. Section 204, Compromise, Settlement or Withdrawal of Derivative Action. Where proceedings in which a member or a director intervenes, as the case may be, with leave of the court are brought under subsection 5 of Section 201, the proceedings shall not be settled or compromised or discontinued without the approval of the court. Section 205, Representative Actions. Where, under a section of this Act, it is provided that if legal proceedings are instituted by a person, that person shall sue in a representative capacity on behalf of the person and any other member of a class. A. That person may commence proceedings in that representative capacity without obtaining the consent and approval of any other member of the class represented and, subject to paragraph B of this section, that person shall have the sole conduce of the action and any other member of the class shall not be regarded as a party to the proceedings or liable for the cost of the proceedings. B. A member of the class represented may at any time before final judgment apply to the court for leave to be made a party to the proceedings whether as co-plaintiff or otherwise, and the court may grant leave on the terms regarding the conduct of the action or otherwise that it considers fit, and if the leave is granted the applicant shall become a party to the proceedings and liable accordingly to have an order for costs made against that applicant. C. A judgment given in the action shall bind and inure to the benefit of the members of the class represented, whether or not they have intervened in the proceedings in accordance with paragraph B of this section. D. The proceedings shall not be dismissed, settled or compromised without the leave of the court, which may order that notice of the proposed dismissal, settlement or compromise shall be given to the members of the class represented and any other persons. E. The proceedings under this section shall be supplemented by the provisions of Section 200. And F. This section shall not affect the validity of an agreement between the members of the class represented, relating to contribution towards the cost of the party or parties suing in a representative capacity. Skip sections 206, 207, 208, 209 and 210. Section 211. Company Secretary. 1. A company shall have a company secretary who shall possess the qualifications specified in subsection 3. 2. The company secretary may be a body corporate except that the body corporate must have as one of its promoters, subscribers, directors, or operating officers, a person who is qualified to be a company secretary. 3. The directors shall not appoint a person as a company secretary unless that person a. has obtained a professional qualification or a tertiary level qualification that enables that person to have the requisite knowledge and experience to perform the functions of a company secretary. B. has held office, before the appointment, as a company secretary trainee or has been articled under the supervision of a qualified company secretary for a period of at least 3 years. C. is a member in good standing of 1. the Institute of Chartered Secretaries and Administrators, or 2. the Institute of Chartered Accountants, Ghana. D. having been enrolled to practice, is in good standing as a barrister or solicitor in the Republic, or E. by virtue of an academic qualification, or as a member of a professional body, appears to the directors as capable of performing the functions of secretary of the company. 4. For the purpose of paragraph A of subsection 3, a professional or tertiary level qualification is a discipline with an offering in company law practice and administration. 5. Unless the constitution of a company otherwise provides, the company secretary shall be appointed by the directors for the term, at the remuneration and on the conditions that the directors consider fit, and may be removed by them, subject to the right of the company secretary to claim damages from the company if removed in breach of contract. 6. Where a company carries on business for more than 6 months without a company secretary, the company, and every officer of the company that is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day that the company continues to carry on business without a company secretary after the expiration of the period of 6 months. 7. An act required or authorized to be done by or to the company secretary may, if the office is vacant or there is not for any other reason, a person capable of acting as company secretary, be done by or to an assistant or a deputy company secretary or any other officer of the company appointed by the directors to be acting company secretary. 8. The company secretary shall, before assuming office, lodge with the company for onward transmission to the registrar, the written consent to serve as a company secretary. Section 212, Duties of a company secretary. The duties of a company secretary include a. assisting the board to comply with the constitution of the company and with any relevant enactment. b. keeping the books and records of the company. c. ensuring that the minutes of the meetings of the shareholders and the directors are properly recorded in the form required by this act. d. preparing and issuing out notices in the name of the company. e. ensuring that the annual financial statements of the company are dispatched to every person entitled to the statements as required by this act. f. ensuring that all statutory forms and returns are duly filed with the registrar. g. maintaining the statutory registers of the company. h. providing the board with guidance as to the duties, responsibilities and powers of the board and on the changes and development in the laws affecting the operation of companies. 1. Informing the board of legislation relevant to or affecting meetings of shareholders and directors and their failure to comply with the legislation and reporting accordingly at any meeting. And g. advising the directors on their responsibilities as directors. Section 213, Avoidance of acts in dual capacity as director and company secretary. Where a person acts as both director and company secretary of a company, a provision requiring or authorizing an act to be done by or to a director and a company secretary shall not be considered as done if the act is done by or to that person acting in both capacities. Skip sections 214, 215, 216 and 217. Done.